Hello and welcome to this talk on the BIS Guidance on Whistleblowing. My name is Declan O'Dempsey. I'm a barrister at Cloisters Chambers. The guidance, which was issued in March 2015, gives a quick rundown of what whistleblowing is. Basically, when a worker passes on information concerning wrongdoing and the worker reasonably believes one, that they're acting in the public interest, so it's not a personal grievance or complaint, and two, that the disclosure tends to show past, present or future wrongdoing falling into one of these categories. So a criminal offence, this will include fraud or financial impropriety, failure to comply with an obligation set out in law, miscarriages of justice, endangering of someone's health and safety, damage to the environment, or covering up wrongdoing in any of those categories. The guidance talks principally about the employer's responsibility. The employer must create an open, transparent and safe working environment where workers feel able to speak up. You should welcome information being brought to the attention of management, and so it's important to have policies to recognise that workers are valuable ears and eyes, to create an open and supportive culture where the worker feels comfortable making a disclosure and doesn't fear the consequences of disclosing. You should implement training, mentoring, advice and other support systems to ensure workers can easily approach a range of people. You should deal with a whistleblowing disclosure when it is first raised and resolve the wrongdoing quickly. So, looking at that more closely, having a paper policy is not enough. It's important to communicate it. So let all the workers know about the policy and make sure that they know how to make a disclosure. If you recognise a trade union, then you should create the policy with that recognised trade union. You should have training at all levels of the organisation on the effective implementation of whistleblowing arrangements. When a person makes a disclosure, you should explain the procedure to them again, and in particular they will probably want to know whether there will be feedback from their disclosure. The whistleblower may expect to be able to influence your action, or even to decide for themselves whether the issue has been resolved. However, you, as the employer, decide whether the issue has been resolved. It's for your organisation to be satisfied that the disclosure has been acted on appropriately and that the issue has been resolved, but there should be clear and prompt communications and feedback to the whistleblower. This feedback is vital so that the whistleblower understands how the disclosure has been handled and dealt with, because if they're unhappy with the process or the outcome, it makes it much more likely that they will approach other individuals or organisations to make disclosures. This will include the first of the external people that they are likely to go to, namely a regulator or a prescribed person. Remember that what is important is that the disclosure should be, or be reasonably believed to be, in the public interest. So it is possible for a whistleblower to believe themselves to be blowing the whistle when in fact they're just airing a personal grievance. The key is whether the worker reasonably believes that they are acting in the public interest. And so therefore personal grievances and complaints are not usually covered by whistleblowing law, and your policy should make this clear. However, it's important to note that an individual grievance can give rise to a protected disclosure if there's a reasonable belief that the disclosure is in the public interest. There's guidance for whistleblowers to which your policy can draw attention, issued by the government, and Acas has also issued guidance on whistleblowing and grievances. So what should be in your policy? You should explain what whistleblowing is and what it is not. You should give the procedures, and you should make sure people know their rights and what their internal protection is. You should show your commitment to the concept of protecting whistleblowers and encouraging it, and signpost whistleblowers to places where they can get help. It's important that the policy should not just rest on the paper, it shouldn't just be mere words. So you should have training for everybody on the arrangements that you put in place. You should have specified people with whistleblowing responsibilities, and management should lead by an example of openness and creating an open culture. You should include the handling of whistleblowing disclosures as part of discipline and grievance training for managers and staff, and the training should be regular. One of the things that constantly happens is that managers are trained once in an area and then never look at it again, and of course that fades quickly out of their memory. So how do you deal with a whistleblowing disclosure? You should equip your managers with the knowledge and confidence to make judgments as to how to escalate matters, and obviously having a clear policy and good training can help. You should decide whether you're going to have a designated team or a particular manager to deal with whistleblowing disclosures, or whether you're going to ask external consultants to deal with them, for example by being a point of contact for the whistleblower, or by being the people who come and investigate. So what do you do in the particular case? You should hold a meeting with the whistleblower and gather all the information you can to decide what to do about the allegation of wrongdoing. If that resolves the matter, all well and good. If not, then you should consider, as appropriate, having a formal investigation. Remember that even if the allegation is false, it doesn't entitle you to punish the whistleblower in and of itself. And as with any management decision of this nature, you should keep records of investigations and also keep statistics on the number of disclosures that you're receiving. So what happens when a worker blows the whistle to someone other than the employer? The first group that they may go to is not actually dealt with in the guidance. A whistleblower may disclose to the person with responsibility for the subject matter of the disclosure, so this might be the client of your business. But the guidance thinks in terms of the whistleblower next going to the prescribed persons, such as regulators and professional bodies, or for example MPs, to make their disclosure. And this is the next level of protection. Whether they've gone to a prescribed person depends on them going to the person who is prescribed for the purposes of the subject matter of the disclosure. So for example, it might be an auditing issue, and you would look at those who deal with auditing matters in the statutory instrument which deals with the list of prescribed persons, which you can see in the materials supplied with whistleblowing for whistleblowers, parts 1 and 2. So in summary, the worker is best protected if the disclosure is made to the employer. Next would be disclosure to the person with responsibility for the subject matter of the disclosure. Next best protected is disclosure to a prescribed person. Then, if disclosure is to someone who is none of those, so to a wider audience, then protection tends to be slight, save in exceptional cases, and we'll look at those now. So when people go to other persons, and in particular the media, what is the protection regime? Well, if a worker goes to the media, they can, says the guidance, expect in most cases to lose their whistleblowing protection. I'd suggest you don't make the assumption that they have done that, because it is slightly more complex than that. They will only be protected in certain exceptional circumstances, and to be protected they must reasonably believe that the information they disclose and any allegation contained in it are substantially true. They cannot be acting for personal gain. Unless the wrongdoing is exceptionally serious, if they haven't already gone to you or to a prescribed person, they must have a reasonable belief that you will subject them to a detriment, or that you'll conceal or destroy evidence if they do so. And their choice to make the disclosure in that way must itself be reasonable. If a worker feels that they have been unfairly treated as a result of disclosing, they can make an application to an employment tribunal. Now, they have 3 months to do that, beginning with the date on which they experience the detriment, but they must first, before presenting a claim to an employment tribunal, go through Acas's early conciliation scheme. The early conciliation may extend the statutory time limit. If the worker is dismissed or claims constructive dismissal, they can make a claim to an employment tribunal to have been what's called automatically unfairly dismissed because of whistleblowing. Now, significantly, there's no minimum qualification period for an employee to have been employed before claiming this, and there's no upper limit on compensation. It's thought to be best practice to keep the identity of the whistleblower confidential, but this may mean that it's difficult for them to obtain protection. It's worth asking these questions to see whether you're committed to protecting whistleblowers. Do you encourage whistleblowing as a way to report wrongdoing and manage risks to your organisation? Have you got a policy or appropriate written procedures in place? How do you ensure that the whistleblowing policy or procedures are accessible easily to all workers? Do you make workers aware of the policy or procedures through all available means? Do you provide training to all workers on how disclosures should be raised and how they'll be dealt with? And how often do you provide that training? Are managers trained on how to deal with disclosures? How are you creating an understanding that all staff at all levels of the organisation should demonstrate that they support and encourage whistleblowing? Do you confirm to staff that any clauses in settlement agreements don't prevent the workers from making disclosures in the public interest? Do you ensure your whistleblowing policy or procedures clearly identify who can be approached by workers who want to raise a disclosure? You should ensure a range of alternative persons who they can go to in the event that they can't approach their manager. Have you talked to the union so that the representative from the union could be an appropriate contact? Do you create an organisational structure where workers feel safe to raise disclosure in the knowledge that they won't face punishment for having done so? Do you give a commitment that any detriment towards an individual who raises a disclosure is not acceptable? What commitment do you make that all disclosures raised will be dealt with appropriately, consistently and fairly and professionally? Do you undertake to protect the identity of the worker who is raising a disclosure? unless required by law to reveal it, and do you offer support throughout with access to mentoring, advice and counselling? You should provide feedback to the worker who raised the disclosure where possible and appropriate, subject to other legal requirements. And feedback should include an indication of the timings for actions.